This is just an audio and video test.
Yes, I can see and hear you.
Thank you so much.
Casey, I'm just checking you can hear me as well.
Yes, I can.
Thanks so much.
Casey, this is Verity. Can you hear me?
Yes, I can.
Thanks.
morning. Before I officially call our case, let me just check in with my court reporter. Tracy, are you ready?
I'm ready.
All right, great, thank you. Now calling proceeding number 23A-0589EG. Today is May 17th, 2024, and it is 9:00 a.m. This is a remote evidentiary hearing in the matter of the application of Public Service Company of Colorado for approval of its combined electric and natural gas demand side management and beneficial electrification plan for calendar years 2024 to 2026. We were scheduled for this hearing by decision number R23-0086-1, which was confirmed by decision number R24-0330-I. My name is Melody Mirbaba, and I am the administrative law judge assigned to hear this matter. Consistent with commission practice, we are webcasting this hearing on the commission's website. That includes the video and the audio, and we have a court reporter taking down everything that's being said. Let's get started with entries of appearances. As I noted the last time we met, I'll just say it again. If I mispronounce anyone's names or refer to anybody by the wrong gender pronoun, please, no, I don't mean any offense, and just correct me and I'll do my best moving forward. All right, so let's get started with public service.
Good morning, Your Honor. My name is Tyler Mansholt, and I'm joined by my co-counsel, Ms. Lauren Caliendo. Thank you.
Good morning. For the Colorado Public Utilities Commission trial staff, who I'll refer to as staff.
Good morning again, Your Honor. This is Assistant Attorney General Ross Smith, and I'm joined by my co-counsel, Assistant Attorney General Katie McLaughlin, on behalf of trial staff.
Good morning. And for the Utility Consumer Advocate, the UCA.
Good morning, Your Honor. Michelle Singer Nelson, Assistant Attorney General, appearing on behalf of the UCA.
Good morning. For the City of Boulder.
Good morning, Your Honor. This is Veronique Van Giem, appearing on behalf of the City of Boulder.
Good morning. For Western Resources Advocates, who I'll refer to as WRA.
Good morning, Your Honor. Parks Broso, appearing on behalf of Western Resource Advocates.
Good morning. For the Natural Resources Defense Council and the Sierra Club, who I'll collectively refer to as the Conservation Coalition.
Good morning, Your Honor. Matt Gerhart, appearing on behalf of the Conservation Coalition.
Good morning. For the Southwest Energy Efficiency Projects, or referred to as SWEEP.
Good morning, Your Honor. Robert Ragonin, appearing on behalf of SWEEP. I'd also like to enter the appearance of my co-counsel, Michael Hyatt.
Good morning. For the City and County of Denver.
Good morning, Your Honor. Mandy McDonald, Assistant City Attorney on behalf of the City and County of Denver.
Good morning. For the Colorado Energy Office, who I'll refer to as CEO.
Good morning, Your Honor. Jessica Lowry, Second Assistant Attorney General representing CEO. I'd also like to enter the appearance of lead counsel on this case, Ms. Jackie Colicchio. Ms. Colicchio will be joining us around 10:15 this morning.
Okay, yeah, I think she was with us on Monday. Good morning. For Energy Outreach Colorado, or EOC.
Good morning, Your Honor. Gabriela Stockmeyer on behalf of EOC. And I'd also like to enter the appearance of Daniel Rubin for EOC, as well as Mark Dutsky.
Okay, and we may need you to turn up your microphone or somehow your volume. You're coming out a little bit soft-spoken.
Okay, I will do so.
Okay, thank you. And for the Energy Efficiency Business Coalition, referred to as EEBC.
Good morning, Your Honor. Mark Dutsky at the law firm Dietz and Davis, representing EEBC, and also entering the appearances of Dana Rubin and Gabby Stockmeyer for EEBC. Thank you.
Okay, thank you. Good morning. For the Clean Energy Economy for the region, referred to as CLEAR.
Good morning, Your Honor. Sarah Keene at the law firm Kaplan, Kirsch, and Rockwell on behalf of CLEAR. Thank you.
Good morning. For Climax Molybdenum Company.
Morning, Your Honor. Richard Thaniot for Climax Molybdenum Company.
Good morning. for the Colorado Energy Consumers, who I'll refer to as CEC.
Good morning, Your Honor. Michelle King of the law firm Holland and Hart. I'm here on behalf of the Colorado Energy Consumers. And with me, I'd like to enter the appearance of John Sherry.
Good morning. And for Iconergy Ltd.
Good morning, Your Honor. Mark Valentine from Keys and Fox on behalf of Iconergy.
Thank you. All right, so I want to start this hearing by checking in. I think the best way to do that is to check in with public service. When we last met, the parties were going to try to explore whether there was any settlement possible in this case, and we were going to figure out based upon that how to proceed.
Yes, Your Honor. I have good news to share. Parties essentially locked themselves into a virtual meeting room session the last several days to re-explore settlement options. And those negotiations over a long time frame with lots of party dialogue and tremendous efforts were successful. And the parties now have reached a comprehensive settlement in principle. All parties are joining on all issues of the settlement with one exception. And that exception is that Icon Energy is not entering the settlement and is taking no position on it. Otherwise, the parties are prepared to turn the settlement in principle into a full drafted settlement agreement that is comprehensive to submit to Your Honor in this proceeding. And I have some recommendations I could provide about follow-along processes, but I will pause there.
No, I would love to hear. I guess I'll start by saying I know that I'm sure that was not an easy task to accomplish to reach an agreement. So I just want to thank the parties for your efforts. I think before I have you propose a process, I just want to see if Ms. King, she's raised a hand, so I don't know if she has something that we should hear right now. So Ms. King, why don't you go ahead and let us know what you have to say.
Thank you, Your Honor. I just wanted to caveat that while we've recommended that CEC join the settlement, we don't have client authority to say that we are joining yet. And I just wanted to make that clear, although we have indeed recommended that they do join.
Okay, thank you. Thank you for that clarification. I appreciate that. Okay, Mr. Mansholt, what would you propose in terms of next steps?
The company and the parties will need a little bit of time to complete the settlement drafting, as well as draft a supporting motion. And I will give some insight that there's a little bit of budgetary modeling inherent in that process that will take a little bit of time on the company's end. And so we accordingly propose a date of no later than May 30th for the filing of the actual settlement agreement and the supporting motion. To have a hearing on the settlement, we would propose a date of July 15th. And to the extent any additional days are necessary, the company would propose July 16th to have any additional days of hearing. I will note on these 2 days of hearing that with a group of interveners this large, there are conflicts that will tend to arise. And so some parties may find the combination of July 15th and July 16th difficult. But that is what the company understands to be having the most comprehensive support from party positions. And I don't want to speak for parties from individual conflicts they may have, but that is the company's understanding of what has the most consensus. At the settlement hearing, parties could provide their live direct testimony as they deem necessary on their support of the settlement. And then the witnesses would be available to address your questions on the settlement. And as one kind of a preview issue prior to that hearing date, the parties themselves would find it relatively helpful to know whether certain witnesses could be excused from hearing prior to the hearing date, to help plan their schedules and to know whether any of them should further prepare for the settlement hearing.
Okay, well, I'll say as an initial matter that I think filing your settlement on May 30th would be fine. And the hearing dates that you've given are also available. And that definitely would give me ample time to review the settlement agreement, understand it, and frankly, and I'm not, it seems like that might be a slim chance, but if I look at that settlement agreement in that interim and end up deciding I don't need to hear from the parties, and I can always vacate those dates. Now, with a case as big as this, it seems like probably more likely than not, I'm going to have some questions about the agreement. So I think we ought to absolutely plan on having a hearing, but there is always a chance that that could go away. So I'll just say this timeline I'm fine with, but let's hear, I will just ask if anybody has an objection to what the company has proposed, to go ahead and unmute yourself. And if, and then I'll have you speak, and I'm going to take silence to mean there is no objection to what's been proposed. So I'll go ahead and pause because I know sometimes it can take a minute or two to get yourself unmuted. You can also use the raise a hand feature. More than anything, I just need to know who to call on. Okay, I wanted to make sure I gave everybody a chance to signal whether you've got an objection to what's been proposed. And I'll just note for the record that at this point, nobody has signaled that they oppose the timeline that Public Service has proposed. And I'll just say I've been, the way that Zoom puts people's images on the screen, I have to kind of scroll through screen by screen to make sure I've looked at everybody. And at this point, I don't see that anybody has objected. So with that, we'll go ahead and establish May 30th as a deadline to file the settlement agreement. And you can also file your motion at that time, though frankly, it doesn't need to be filed that same day. You can file it at a later date, because I'm assuming your motion is going to say nothing more than please approve our settlement agreement without any modification. So it's not like that's going to be alter anything in our case at the end of the day. So if you need a little bit more time on that, that's fine. It just needs to get in before the hearing. Make sure that when you file the settlement agreement that you mark it as a hearing exhibit and use the next number in Public Services hearing exhibit sequence. If you just plan on that in advance, that'll avoid last minute scrambling if there's any issues with it. That'll probably be the most important exhibit that we've got for our hearing. So we'll have May 30th, the deadline for that. And then I'm gonna set the hearing for, I think it would be best to just reserve 2 days. We may not need 2 days. In fact, we may not need any days, but I feel like it would be better to have them than not. So we'll set the hearing for July 15th and 16th, starting at 9 a.m. Is it safe to assume the parties would still like that hearing to be held fully remotely? I guess I'll say this. If you don't want it fully remotely, please speak up now. All right, nobody has spoken up, so I'm going to take that to mean that everybody agrees it should be a fully remote hearing. So that is how I will schedule it. In terms of witnesses, I can say that based on my experience, most likely I'm going to want all of the company's witnesses available. And part that's because there can just be some questions that arise out of the settlement agreement that only the company can answer. Let's make sure all of the company's witnesses are available. Generally speaking, I think it's also helpful for staffs and the UCAs and possibly CEOs witnesses to also ensure that they are available. In terms of other parties' witnesses, let me just take a quick look at some of the notes that I already have to see whether that would advise in favor of specific other witnesses being available. So these witnesses, I think it would really depend upon what the settlement ends up looking like. But I can tell you that I did have at least one or two questions for WRA's witness, Ms. Valentine, and Denver's witness, Daniel Shea. But again, I may not need to ask those questions just depending on what the settlement looks like. And I possibly might need EOC's witness, Luke Alderton, available. Again, though, that may depend again on where we end up with the settlement. I also had, I think, at least one question for EEBC's witness, Howard Geller. So once I get the settlement agreement, that may change. And I can certainly do my best if I'm able to make that determination in advance of the hearing to let you all know whether those witnesses can be released. I am certainly willing to work around witnesses' schedules. I realize that, we've had this change that was last minute, and these dates are probably difficult for so many people to be available, especially all the witnesses. So I'm happy to work around any scheduling difficulties that witnesses might have. And frankly, because we're doing this remotely, I think that does make it a lot easier for people to appear. So hopefully that's at least enough information for you all to know who I definitely think you ought to make available and who we may need to have available for the hearing. All right, so given these developments and the timeline that we're talking about for a hearing, I think that, I've got the information I need to decide whether extraordinary conditions exist to extend the statutory deadline under Colorado Revised Statute 40-6-109.5, paragraph 4. I'll just go ahead and let you all know that under the current deadline, I calculate that my recommended decision would have to issue essentially by July 19th. And seeing how the timeline that we have here set out, I'm not going to be able to have that done, which means that the commission won't issue a decision consistent with the current statutory deadline. So from my view, we do have extraordinary circumstances, especially in light of the fact that we're looking at a potential comprehensive settlement that I think would really be in everybody's best interest and serve the public interest to avoid the increased costs of litigation. So I do believe extraordinary conditions exist, but the point of noticing this issue for a hearing is to make sure that everybody else has the option of speaking up on that. So what I'm going to ask is that if anybody disagrees with what I've just found, which is essentially, I do think we've got extraordinary circumstances, to please signal by unmuting and or raising a hand, and then I would like to hear from you. And then I'm also going to ask you to essentially signal the same if you object to a finding of extraordinary circumstances. I also want, before we get to that, I want to caveat that my concerns about significant delay that I expressed during a hearing on Monday, they continue. It does not go away. And even, you know, we go down this path and there is more time for a commission decision. That does not mean that I am going to slow down in getting a decision issued as quickly as possible. And frankly, having a comprehensive settlement will make that feasible. All right, so with that, I'll go ahead and pause and ask for folks to unmute or raise a hand if you object to a finding of extraordinary circumstances or if you disagree that extraordinary circumstances exist as contemplated by the statute. And I'll pause for a moment just to make sure everybody has a chance to hit the right buttons. Ms. Keene.
If I may ask a clarifying question, are you proposing to go out the entire 130 days or just leaving that open as needed at this point?
I think under the statute, it's not, I can't just say 60 days. It's either the full 130 under the statute or none at all. And so it would be the full 130. However, from my perspective, I don't plan on trying to use up as much of that time as possible. I plan on trying to get it done as quickly as possible because, like I mentioned on Monday, getting this done within a reasonable time frame is important, and I really do want to avoid significant delay. And I'll just say, as I signaled in the decision I issued a week ago, I think we were headed down this path even without a settlement. And if that were the case, I would most likely be looking at using more of as much of that time frame as possible because there's just so many issues. I mean, even just to outline everything that the plan is asking for would be a 600-page decision, which I will not do. So I hope that helps clarify.
Thank you. I appreciate the clarification and no objection.
Sure. Okay. And again, I'll pause and see if anybody else has anything more to add. And again, that's to signal whether you object or disagree that extraordinary circumstances exist as contemplated by the statute. Okay, I'll note for the record that nobody has signaled any objection to a finding of extraordinary circumstances or indicated that they disagree that extraordinary circumstances exist as contemplated by Colorado Revised Statute 40-6-109.5, paragraph 4. Based on the circumstances that we are in, I do make that finding, and I will extend the statutory deadline by 130 days. As already discussed several times, I certainly do not plan on taking up all of that time, but there is some time that is going to be needed to get this done. All right, so with that, I'm not sure if there's anything else we need to address before we recess, but I do want to turn back to the company and the parties. Mr. Manschultz?
Yeah, I apologize, Your Honor. In terms of the witnesses being excused, I did have a chance to just to raise one thought, and the message is loud and clear that all the company's witnesses should be available and ready at the settlement hearing dates. But I will suggest that to the extent there's any further guidance from Your Honor on witness excusals, we have one witness by the name of Mr. Michael Bogner who submitted just one piece of brief testimony in supplemental direct. And that piece of testimony did not receive any feedback or direction from any of the parties. And I don't believe the settlement itself will be implicating that piece of testimony. So to the extent Your Honor gives any further guidance, I would make a small plug for thinking about the release of Mr. Michael Bogner. But that's all. Thank you.
Okay, And I read his testimony, and frankly, even as of Monday, when we were getting ready to start our hearing, I didn't have questions for him. So it is, I would say, more likely than not that I won't have questions for him at the evidentiary hearing. I just can't say that with any, it's even going to be hard to say that definitively leading up to the hearing, because there have been occasions in the past where I've asked one witness a question who I thought would know the answer, and then they would say, no, this other person is the best person for that. So it's hard to say with 100% certainty, even after I get the settlement. I do think it's most likely I won't need him. Because the agreement is being filed so far before the hearing, I hopefully will have an opportunity to figure out, have a better sense of that before we get up to the hearing. He probably is still going to have to be available just in case, but again, I'll do my best. And if I've got a high degree of certainty, there's nothing is going to touch a subject that he's going to need to address, and I will absolutely let you know. Is there anything else that we should talk about before we adjourn? All right, I am taking everybody's silence to mean that there is nothing else that we need to address. I will be writing up what happened today and issuing a written decision on this probably within the next week. Thank you again for your efforts to reach a comprehensive settlement. As I have mentioned, I do think that, especially in a case like this, when the parties can come together, it benefits everybody. So I really do appreciate everybody's efforts. All right. Oh, Mr. Smith has raised a hand. So before we adjourn, Mr. Smith?
Your Honor, I just wanted to take a moment on the record and extend my appreciation to the company and the parties for engaging in a productive settlement discussion, and really appreciate everyone working really hard over the last few days. So I want to recognize that, and certainly want to recognize the company for coming back to the table and everyone being able to come to a good agreement. So thank you, and thank Your Honor for your patience.
I really do. I agree with you 100%. I really appreciate all of your efforts. I know that this is a really heavy lift on your part, and I really appreciate it. Okay, so with that, we will adjourn our hearing. Thank you all.
Thank you.
Thank you. Bye.
Bye.